Good evening. Welcome in daily UPSC editorial audio program. I in society. The Times of India. Job half done. Live in fear. Uniform patriarchal code. Now the full editorial. I in society. The Times of India. Laws need to keep up with times. That means lawmakers should listen to young people. Society does not stand still. The meaning of right and wrong, just or unjust, even traditional or modern, keeps shifting in new directions. Consider that most enduring stratification, patriarchy, its look has been changing decade by decade, let alone century by century. Male domination could hardly remain impervious to young Indian women's literacy rising from 40% to 96% since 1981. A society undergoing such momentous change bears out older laws at express pace, like India's new criminal law codes. This is the most welcome quality of the Uttarakhand UCC bill to meet needs of society as they are rather than as they were. But such legislations need revision whether they suffer tone deafness, particularly to young people's thinking, living, doing. A lot of this dissonance is centered around assertions of individuality. Marriage is seen as being in service of family, live-in relationship or not. Why doesn't Uttarakhand government feel the need of properly justify its plan to aggressively track live-in relationship, even though that this is unprecedented because it is assumed that all parents will tacitly consent and clap. Lawmakers and judges are often only loyal to parents' generations. Their jobs requires require them to be much more open. Young people are pulling away from past scripts to write uncharted stories. Old-headed institutions are made anxious by this confident adventurism. But while graybeards in entrenched power can inflict setback after setback on young ones, there is no stopping this tide. They will keep pursuing legislation of gay marriage, criminalization of marital rape, surrogacy rights for singletons, mandatory paternal leave, unsurveilled live-in relationships. Yes, the young lack the political half of usual identity-based mobilization. Yes, they don't threaten other people's life or property. They only challenge world views, like income taxpayers, 3% of whom contribute to 38% of total collection. They have no vote value, and yet they disregarding young people's voice in a giant socio-economic self goal. How will young people chained up by past social mores, individual desires bent to bygone codes, live up to their potential? That is why it is in urgent national interest that lawmakers be guided by what Supreme Court said in its landmark right to privacy judgment. States should not intrude upon a citizen's personal liberty. In fact, protection of liberty is one of states' key remits. The state is not Papa. In any case, Papa doesn't know best. Those fearful of change doesn't uh, doesn't crush those pushing it. Job half done. Bill to prevent exam cheating tackles supply side. Key questions. Why there a huge demand for cheating? Students who spend years preparing for government exams truly feel cheated when some fellow candidates cheat. Government of India has tried to address this growing problem with a new bill cleared by Lok Sabha on February 5. Severe punishment. The Public Examinations Prevention of Unfair Means Act 2024 sets store on deterrence through harsh punishment. Offences under this legislation are cognizable, non-bailable, and non-compoundable. In design, it is on par with legislations dealing with grave crimes. all about supply. Cheating in exams need to be understood from both demand and supply sides. Government of India's bill focuses exclusively on supply side. Punishments are all aimed at collusion and disruptions that may facilitate cheating. That's necessary but not sufficient. Demand measures. Students are absent from bills provisions. They are buyers of dodgy services that lead to exam malpractices. It is likely that cheating law sidesteps addressing demand issues because core problems are beyond its scope. Craze for government job. ASER's 2023 survey of rural students threw up insightful result about their aspirations. Most popular choices among boys were army and police post. Police was a popular choice among girls too. ASER survey showed that underlying virtually all responses were students' assumptions that good jobs are only to be found in government institutions. Quality matters, but government jobs are a small fraction of total jobs. But students' responses showed that they are preferred because they offer job security and pension and command social respect. This feeds into a huge coaching ecosystem and eventually creates demand for clearing exams and for means to cheat exam systems. So this bill may deter cheating to an extent, but it is unlikely to really dent it. Where what student needs are better quality jobs. Live in fear. Uniform patriarchal code. Uttarakhand UCC puts a bullseye on living relationships. Women's agency is weakened. Interfaith couples are worse off. Cops community get to judge what happens in bedrooms. Uh, Mihira Sood, the writer, is a lawyer and scholar in the field of women's rights. These columns have long supported the idea of a uniform civil code as a path to further both secularism and gender equality. But the bill tabled in Uttarakhand's assembly, this bill undermines both these goals. To start with, it retains several problematic provisions of existing Hindu law. Different marriageable ages for men and women 21 and 21 and 18 respectively. Resolutions of conjugal rights limits limited grounds of divorce. It is also poorly drafted with certain sentences completely incomprehensible. There are obvious incongruities that will only serve to keep lawyers busy. Compulsory registration. These include why an adult woman who is capable of getting married at 18 without her parents' involvement is not free to enter a live-in relationship till she is 21. Second, maintenance is a gender neutral provision in marriage and available regardless of the ground of divorce. But for live-in relationship, only the woman can claim maintenance and only on grounds of desertion. Third, there is no penal consequence of non-registration of a marriage, but for a live-in relationship, it invites imprisonment. This provision threat is the most troubling aspect. Partners intending to enter into such a relationship have to submit a statement to the registrar and repeat this when they wish to end the relationship. In all cases, any statement for registration has to be submitted to local police and where either party is less than 21 to their parents as well. Non-registration can be met with imprisonment as well as a fine. Official justification. Officials have justified this as a demand of parents in wake of a number of crimes committed against women by cohabiting partners. Recognition of such relationships, it is argued, may provide the same measure of protection to women as marriage does, and many western countries also have legal obligations arising from living relationships or common law marriages. Let's break this down. First of all, registration does not prevent crime. We know this well from data on dowry deaths, domestic violence, sexual abuse, and innumerable other acts of physical cruelty that take place even within the protection of matrimony. Secondly, what is provided for in other countries is recognition of long-term living relationships where after a period of few years certain protections like maintenance and child support may be available on termination, protecting vulnerable parties if a relationship ends is very different from what is being done in Uttarakhand. Infantilizing women. Involvement of parents for couples who are above 18 is simply illegal and betrays that this is not at all about empowering women but the opposite. Infantilizing them or treating them as incapable of making their own decisions. It is about protecting family and community honor, of which women are still seen as vessels. This is further underlined by the fact that registrars do not simply register such arrangements but also have the power to deny permissions. This denial can be done on various grounds, most problematically by registrars opening that consent has been vitiated by coercion, undue influence, misrepresentation, etc. On the face of it, it is an in, innocuous provisions, but any person even halfway conversant with today's politics knows that there is far more to it. The target here is obviously interfaith couples who frequently opt to live together as they try to bring their families around. Often, false accusations of forced conversions or misrepresentation of religious identity are made by a woman's parent to put an end to their daughter's consensual interfaith relationship. Moral policing. Perhaps most shocking is Section 386, which could allow any third party to submit a complaint that a live-in relationship has not been registered. The law thus creates insurmountable obstacles for such couples who would be unable to rent any accommodation without showing the landlord their registration document, not to mention neighbors, Romeo Squad, local religious chapters, and countless other busybodies who would feel legally entitled to invade their privacy and play moral police. This is an unacceptable level of intrusion that government is encouraging. Oppressive law. The ostensible aim of the bill was gender equality, but the chipping away of women's privacy and autonomy lay bare its patriarchal moorings. Any woman who wish to enter a live-in relationship will be subjected to an infantilizing level of scrutiny where police will collude with her parents or even third parties to deny her wishes, particularly if it is an interfaith relationship. At no point is her agency or individuality respected. It follows the model of locking women up for their protection rather than empowering them with rights and freedoms. A modern civil code would separate religion not just from governance but also from the sphere of collective rights, treating it as a matter of individual belief, of choice rather than birth, and where interfaith partnerships, live-in relationships, or any other choice made by consenting adults are made easier rather than more difficult. What we have instead in this outdated patriarchal code that invites police, neighbor, and pretty much anyone else into our bedrooms. Is this a blueprint for the entire country? Thank you.